Good morning and welcome to the sixth episode of our webinar series, Coffee with Casey. I'm Casey Hicks, a shareholder and the Chicago office managing attorney here at Weltman, and I look forward to kicking off another exciting episode with everyone. This morning, I'm enjoying a nice cup of caramel coffee. How about all of you out there today? Feel free to send what your drink of choice is this morning through the question feature on the control panel while I go over some quick housekeeping items. This seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. This seminar and the material provided is not a substitute for legal advice from qualified counsel on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address the unique facts or circumstances that may arise in any specific instance, and you should not and are not authorized to rely on this content as a source of legal advice. The presenters advise you to seek competent legal counsel on these topics. This seminar or seminar material does not create any attorney-client relationship between you or the law firm of Weltman, Weinberg, and Reese. All right, now that that's out of the way, as a reminder, this is an interactive session, so please submit any questions you have throughout the presentation through the question button in the control panel. I look forward to having an open conversation with everyone about today's topic, filing suit to judgment. Also, for your information, this webinar is being recorded, and at the conclusion of today's session, a link to the recording will be sent to all attendees. Lastly, there will also be a short survey on your screen at the conclusion of this morning's session. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. And if you have any ideas for future topics, please let us know. Also, we plan to conclude today right at 9 a.m. Central or 10 a.m. Eastern. And with that, Jason, I'll turn it over to you. Welcome.
Hi, good morning. I'm new to Weltman and I'm happy to be here for my first Coffee with Casey. Even though I don't drink coffee, I do have my water with me. So I expect this to be an informative morning. I want everybody to enjoy their coffee, their tea, their water, their Diet Coke, or whatever it is that gets you going. A little bit about myself. I've been involved in foreclosure and collection litigation for more than 10 years. So I'm familiar with service and service-related issues. And I hope you enjoy our discussion this morning.
All right, thank you, Jason. Now, what we're going to try, we're trying something new this morning. We have a quick poll to see what you're all drinking out there. So I'll give you a few seconds to lock in your answers before we move forward. All right, thanks everyone. Jason, with that, I'll kick it back over to you.
Okay, so you've got a loan or a mortgage, whether it's residential or commercial. This is going to be a general overview of what happens when you've got a non-performing mortgage or a credit card or a loan that is in default. So a couple of things that you want to look at. You want to know, do you have any pre-suit notices that are required under the contract? Contract I use generally to cover everything that I just mentioned. So, you know, are there any default notices that need to be sent out, you know, and have you complied with those? Part of that, you want to make sure that you have valid contact information for the consumer or the borrower. You want to make sure that you're able to communicate with them with any collection efforts, and you want to make sure that you can send them the notices. You want to know, if this is an equipment contract, you want to know if you can consider repossession or self-help to obtain the equipment. And then you want to look if it, you know, what you want to determine when you want to retain counsel.
Jason, any tips out there for people on the episode of what would be beneficial to send over to their counsel when they're sending a new collection file for suit?
Yeah, when we get a new file, a lot of times we will receive or we look for the any collection efforts they've done, any notices they've sent, any demand letters. Do they want us to send any pre-suit notices? Are there any Regulation F notices that we need to send? We also would like to know if they've done any skips to determine if they have attempted collection efforts or attempted to reach out to the consumer. We'd like to know, it's good to have payment histories, loan transactions, payoff screenshots, depending on what kind of loan it is, if it's a mortgage or a credit card or a loan. We need to know what the unpaid principal balance is. A good thing that we need all the loan documents, because we want to know when does the loan mature. We need to know we need to verify that the pre-suit requirements have been met. If it's a credit card, we certainly would like, it would be nice to have zero balance statement, which would be your first statement, to final statement charge off, but we don't necessarily need those. We need to have the charge offs date. We like to have the statements showing use of the account, and then statements showing payoff, and we need the last payment date to review for things like statute of limitations. Another thing that, looking for, especially with credit cards, a lot of times people will, it's good to always prepare for the end game, which is trial or settlement or arbitration, whatever it is. I always, when I'm prepping, look for use of the card. And a lot of times I look for things that require ID. So, if you have a statement that is showing travel, because you can't use your credit card to travel without showing ID, or a rental car or something like that. We would like to see, I think that covers everything: charge off, last payment, last statement date, transaction date.
I think so, yeah.
Yeah, so I think that's what we look for. This slide and the next slide bring us our more of the same, with copy of the contract in the next slide. You're going to want, if you're doing a foreclosure, you would want the mortgage. It's nice to have the origination file, or at least begin prepping your origination file, because that's going to come up in discovery if it's contested. With debt buyers or with mortgages, you would want assignments and bill of sale. If it's a mortgage, a lot of times the mortgage has been bought and sold. We all know happens in the industry. So the assignments are good to have. And then if it's a debt buyer, you're going to want your bills of sale so you can attach those to your complaint. With credit cards, you want to have terms and conditions that were sent. And then any, again, payoff information and contact for the consumers. So once you've gathered all that, you've done the review, you've attempted your in-house collection, and you decide that you want to send it to us or your attorney for what we would call litigation, meaning collection attempts have been exhausted, or we're going to continue with collection attempts, but we want to file suit. So once we receive the referral, we're going to determine if there's anything that we need to send, and that would come in the referral. You would let us know if we're going to go directly to suit, or if you want us to attempt collection, or if you want us to attempt collection, or if you want us to redemand or send new notices of default. Once we've made those determinations based on the referral or your request, we will draft the complaint after the time for the notices have expired. Again, that's going to depend if it's a residential or a commercial mortgage. There's different timelines than there are for credit card, consumer, and commercial collections. We'll draft the complaint. We here use verified complaints, so we would draft the complaint, compile the exhibits, and send it back to you. If it's a credit card or a debt buyer case, we will attach the terms and conditions. We will attach the the charge-off statement. And then if it's a debt buyer case, we will review the bill of sale and make sure we have the complete chain of title. That's one thing that I didn't mention when I mentioned the bill of sale and assignments. We always need to make sure that we have the complete chain of title. We'll also review that to make sure that title is accurately reflected in the client's affidavit. Then we'll send the complaint over back to the client for verification. Once we receive that back, then we can file suit. Every county is a little different.
Yes,
So,
yes, they are.
So every county is a little different. They all have their procedures. We do file in every county in Illinois. I say Illinois. I'm licensed in Michigan, Illinois, and Florida, but right now I'm focusing on Illinois. So today we'll focus on Illinois. The complaint is filed. A 30-day summons will be issued. And then there is, on the summons, there's a return date. If we get service, great. If we're unable to serve, or we're having, I don't want to say unable to serve, if we're having difficulty in service or difficulty locating the defendant, we can always request an alias summons. The alias summons doesn't work, we can request 203.1 service, which is special service by special service. You can do that by mailing, but there's certain requirements that we have to meet for that to be granted. That requires a motion and an order. Again, each court on that is different. Casey is going to get more into service because there is a new rule that just came out that Casey is going to discuss, which gives us even more opportunity for service that is brand new, and I'm sure is going to have a lot of questions. One thing that is unique to Cook County, and it's only, Casey, correct me if I'm wrong, but it's only for consumer collections. It's not a requirement for commercial loans.
That's correct.
Is the ERP program, and that's the early resolution program in Cook County. And that is a program that offers the consumer what they call free legal advice. There is at least 2 hearings on that. Sometimes there's more if there's issues with notice or with the program reaching out to the consumer. But that program it can create it's an opportunity for the defendant to kind of connect with us, and if they're interested, then settle the matter. If they've already reached out to us pre-ERP and we've entered into a payment plan, it gives them an opportunity for free legal counsel to have any payment plan or settlement negotiations reviewed by an attorney that's there for them. They don't always go into representation. It's usually a call that's done in the program. If they do that in the first or second hearing, then it's transferred to a trial room. And that usually takes about 5 to 6 weeks. And then you can enter your default judgment, you can set it for trial, you can have your, if they're on a payment plan, you can have the case dismissed, but it has to go through that program. If there's an attorney, it usually will go to a different room. It'll go to 1501. That's on a different track, but the attorney will have to appear and have to opt out of the program. The higher balance files, I think the limit is 30,000. Casey, is that what it is?
That's right, yes. Mm-hmm.
So if you have a loan with 30,000 or more, then you're going to be in the law division. And those in the law division, the cases are generally on a more of a rigid path. And those cases have limitations on service. They're not as lenient on service as they are in the municipal divisions. So I mentioned every county being different. I mentioned some issues with service. In Cook, we will attempt service with the sheriff. Then if the sheriff cannot complete service, then we can look to the other service issues or other service alternatives, sorry. And that would be the motion for a special process server or something that Casey's going to talk about in a minute.
And also we found, like, just through our practice, that the sheriff's office is only successful on service about 30% of the time. So the majority of the time we will be filing a motion for a special process server with the court or through the automatic appointment of our special process server. So that's just something to keep in mind for Cook County cases as well.
And Casey, doesn't the sheriff, they only attempt one time, right?
Correct. And our process server is typically attempting on one summons 6 to 8 times to try to complete service. So that's kind of the difference between the sheriff's office and a process server.
And the reason that we attempt 6 to 8 attempts sounds like a lot when you're looking at, service attempts and time on your file. But once you move to your 203 motion, the court it's best to have more attempts. Some judges require at least 8 attempts, and they require attempts at different times of the day. You can't go for a 203 motion. I wouldn't recommend going for a 203 motion if you've only tried to serve them between, noon and 6. The court is going to want to see that you've attempted it, first thing in the morning, last thing at night. They want you to know that you've tried before work, after work, during work. So 8 attempts sounds like a lot. It sounds like it's like a delay, but it's required for the next step in service. All the counties in Illinois require personal or substitute service. We can try at the employer if they allow it. And then we need court approval, usually motion and order, to go beyond that. One other thing that just came to mind, we always also, if an appearance has been filed by counsel, you can reach out to opposing counsel and ask if they'll accept service. Some, of course, will, and others, want the delay and they won't. But that's always an option. Service by consent is the best. And then, of course, if we are in something like the ERP program, where you're dealing with a pro se party that is less sophisticated in collections or the legal process, and you have entered into a payment plan with them, we send them a stipulation that consents to the jurisdiction of the court. So at that point, you don't need to attempt service anymore, because signing the agreement has, they've consented to the jurisdiction.
Mm-hmm. And with that, we're going to move on and dive a little bit deeper into service by special means. But I just wanted to see if anyone had any questions out there. I'll give you an opportunity to type anything into the chat box if you do have a question right now. And if nothing comes in, then we'll move right into service by special means, because there has been an amendment to the Illinois Supreme Court rules that came out just last week that we're still kind of digesting here in the office as well, because it allows for service by social media, text message, or email. So we're going to dig into that a little bit right now in regards to motions for service by special means. Prior to this amendment, we would file a motion seeking leave of the court to serve by special means. Most of the time, the court would want to see proof of address by an accurate report or affidavit from the process server that the defendant is avoiding service. Basically, the court would be looking for proof that the defendant does actually reside at this address, but we've attempted our 6 to 8 times, plus potentially a sheriff's service, and we still haven't been able to serve this defendant. So most of the time, previously, the court would approve service by certified mail, by FedEx, by posting on the front door of the property. But now with this new amendment, there's going to be other options available. And this rule was just updated on April 24th. And with these new forms of service, the requirement is that it must be in a manner consistent with due process, right? So that seems extremely general, and we are not really quite sure what that is going to be yet, but we did want to make sure we got everyone an update on this rule. So the first portion of this rule, which it allows service by social media. So what exactly does that mean? Well, the rule states that you can send a direct message to the defendant on a social media platform in which the defendant has an active profile. There's not really a definition of what an active profile is at this time. So we're going to keep an eye on this and see exactly what that's going to mean. So with that direct message, you would attach a copy of the summons and the complaint or the petition that you're trying to serve. And within that message, you must include certain language, which is right here on this slide for you, which basically indicates, important information, you've been sued. So with that, we're not really sure how Instagram service or Facebook service or any other social media platform that's out there, how that is exactly going to work at this time. But as of now, it could potentially be an option. And we did have a question come in. So service by special means is for any type of case within the state of Illinois. This is a statewide rule. So it would apply to credit card cases, foreclosure cases, residential or commercial, consumer or commercial debt. So it would apply to any case that you have here within the state of Illinois. Service by email. It's going to be kind of very similar to the service by social media with what has to be included. You're still going to have to give that little bit of a disclaimer, important information, you are being sued. It would attach a copy of the summons and a copy of the complaint or document that you're trying to serve your defendant with. Same disclaimer as the social media. Text message. Service via text message, it's also going to have the same disclaimer that's needed for social media or email service. You would be sending a text message, well, the process server would be sending a text message to the defendant's cellular phone number, attaching a copy of the summons, complaint, or petition that you're trying to serve, as well as within the body of the text, the important information you've been sued. When the motions are filed to obtain leave of court to serve by these three methods, there's going to need to be an additional affidavit filed with the court. This affidavit has to state specific facts or reasons that it's believed that the defendant has recently either sent or received emails or phone calls or text messages from either the email address where we're going to seek to serve or the telephone number that we're going to seek to serve by text message, or any information about an active social media account. Again, we're not really sure what the requirements are going to be for the court as to what it is an active social media account. It's probably going to be a little bit of trial and error. And as Jason mentioned earlier, a lot of judges already have their own special requirements for service by special means within the bounds of the rule. So as we become more familiar with what the judges are going to require for this, we'll be able to keep everyone updated on that. We kind of went over this a little bit already. Jason mentioned the 8 attempts for service by special means and proof that the defendant actually resides at that specific address. Again, if we're going to try to serve by text message, social media, or email, we're going to need to have additional information. So any records that you keep with transmissions to or from your customers or your borrowers, via email or telephone number, it would be nice to have that information so that we can, draft an affidavit like, yes, on such and such date, we corresponded with this person from this email address. We believe this is an active email address. And once we can provide that information to the court in the affidavit, we think we could be successful to be able to serve by this special means. We did have a question come in. Do you have to hire a process server for service by special means via email, text, etc.? I would recommend it. We've already got the process server appointed. You do have to provide a proof of service for every type or manner of service, and that's filed with the court. If there's an issue with the service, then we can go back to the process server and that affidavit. If service is contested, or file a motion to quash is filed, we'd have our process server come in and be able to testify to all the attempts, all the methods that they attempted to serve, and then also be able to testify to the completion of service by this special means, direct message, text message, or email. Once your service is complete, if it's a return date summons, the defendant must then appear in court on that specified date that's on their summons. If it's a 30-day summons, the defendant has 30 days to file an appearance and or an answer. If an appearance or an answer is not filed, then we would file a motion for default judgment. That we do still have that Cook County exception with ERP, the early resolution program. All consumer debt cases must go through that program first, then we can file a motion for default judgment. And other ways we can move for judgment, if there is an appearance or an answer on file, we file a motion for summary judgment. Some counties in Illinois have mandatory arbitration, and if the file cannot be resolved via settlement or through a motion, we would set for trial. We do try to settle, if that's the goal of the client, by pay stip dismissal orders or agreed judgment orders. And I know we went over a lot of information today, especially about the new service rule. So if anyone thinks of any questions after today's presentation, please let us know. Please feel free to reach out to Jason or myself. Our contact information is right there for you guys. You can call us or email us. We'd be happy to answer any questions that you have. And we do have the poll results, but I'm not sure how to share those. New feature today. So I'm not sure if I'm going to get it. We will share those via email. I apologize for that. And with that, I do thank you guys so much for attending today, the 6th episode of this series. I hope you found today's presentation informative and beneficial. Please look out for information about the 7th episode. Will be coming up sometime in July. We'll post that information shortly. And as a reminder, a short survey is going to pop up on your screen today when the webinar ends. Please feel free to share your feedback. We look forward to any topics or suggestions that you have for any future episodes. And thank you so much for attending, and have a great rest of your day. Thank you.
Thank you, everybody. Have a nice day.